Good morning, no, afternoon, everybody. I hope, oh, look, I have a chip on me. That's how my lunch was. I just shoved a bunch of chips in my face because I just left another meeting. Um, I hope that WLPS was fun, even though I'm sure it was also tiring. It is that time of the year when you are exhausted and also there's a million things to do. Um, and we have never figured out a way around that. I suppose that's also because the legal profession hasn't found a way around that. But I send you lots of strength and any reserve of energy that I have your way. I am around in office hours. I know that since we switched to the Wednesday morning, I get very few people who come in. But I really do encourage you to take advantage of this time to talk through synthesis with me, how to make arguments to get some feedback. Because, guys, I'm sorry to tell you this. It's my tough love for the day. There's only 4 weeks left of class, including today. And so, yes, this does inspire general fear and panic. It will all happen because it always does for everyone. But it does mean that now's the time to come and find me rather than at the last minute when I may not be able to be so useful. So that's my uninspiring, non-motivational pep talk for the day. Um, and today we will be, so I'm sorry, we're going to have like 50 million dings coming from faculty council meeting that just ended. And no matter how much you log off of Teams, like completely, it will still keep bombarding you with things. So we may just keep hearing that for the next while. But today what we're going to do is we are going to talk about consideration and look at different kind of factual scenarios that can create very consideration issues. And then we will start looking at contractual variations. And depending on how we go in the next little while, this might be our last topic for the semester. We might have time for one more. We'll see how we go with everything. Now, obviously, before we get into that, I just wanted to bring up this issue that I won't be teaching your section next semester, which is quite sad. And I'm sorry, the dean asked me to take on some special projects for the faculty. And so that required me leaving some of my courses. But I do want to say that the person who's taking over is fabulous. Professor Marcella Aroca will be taking over, and she's a long-term sessional here. She teaches contract every year. She basically wins the sessional award from students every year. Like, I don't know that anyone's won it other than her as a sessional for like the last decade because people really love her. And she and I have talked, and we're going to try and make this, as much continuity as possible between the two of us and the way the class is set up and in the marking, etc. So we haven't ironed out all the details as yet. Your section with Professor Oka will be HyFlex next semester. And so you do have that option for the course. But if I can answer any questions for you now, I will do my best. Does anyone have any questions about what this is going to look like? Okay. Well, we have other things to worry about for right now. We can just deal with what we're doing this semester, but it is both of our intent to make it as seamless for you as possible. And there is very few other people that I would feel comfortable handing over my students to. So I feel quite good that it's her. Okay, so today we have on call Jessica, Jade, Harry, Andrew, and Howard. Brandon?
Hi, yeah. Sorry, just while we're still in the beginning stuff. I know we're going to have the option to do this class in person next semester. And I'm wondering exactly what does that HyFlex mean? Does that mean that we're going to show up and there'll be a screen where the teacher is projected onto, or will the teacher be in the classroom with us?
So, okay, this is to the best of my knowledge because I'm not teaching high flex next semester, but as I understand it, the professor is in the class. So you guys will be able to sign up ahead of time, whether you want to do in person or online. And as I understand it, that's an irrevocable choice. So it's not like you sign up to be in person, but you're like, oh, I'm tired today, and then you stay in bed. So you choose one and you stick to one. The prof is in the classroom. And then it's also logged on to Blackboard or Zoom, whatever is asked. Um, so the professor will kind of be doing the connecting between the two groups because the students won't be able to see each other, the groups that are in class and the groups that are online. We sort of have talked about the idea of having everyone logged in in the classroom as well in the physical space, but I gather that creates some significant feedback. And so it's all a little bit new for everybody because not many of us have actually done it. And so it may be a little bit trial and error, but the idea is one group is physically in the classroom, the professor is physically in the classroom, but the professor is also logged into the virtual classroom, and so can address so the students online will hear the professor, and the two groups of students won't be able to see each other though. Does that answer?
Yeah, I mean, it definitely gives me more clarification. I understand that ILO had a lot of changes due to the horrible personal circumstances of Dean Jacobs, but I don't know. I was just hoping that the other courses wouldn't be set up quite in the same way. I would like to have more in-person instruction.
Well, the thing is that, 50% of students want in person and 50% want to be online. And then the instructors themselves have concerns over their own safety, right? So what we try to do is figure out ways to make as many choices for people as possible. So again, the instructor will be in the classroom with you in the physical classroom, but the high flex method. So what my understanding is, and again, I could be wrong, so please don't go away and say like, Professor Mom, I told us this. But my understanding is that what the administration tried to do is because the university has said we are trying to be 50-50 this semester. And we also need to be able to provide accommodation who anyone who needs to be online for medical purposes, is to try and ensure that across sections, there's relatively the same amount of choice about being in person and being online. So high flex, you're in person, you're in the classroom, and if your colleagues want to be online, then they're online. That is the best we've been able to come up with to kind of fit everybody's desires, which is clearly not an easy thing to do. So any other questions about next semester? Okay, so last class, we looked at the concept of certainty of terms, and that doctrine is the second doctrine that we learn about that is necessary to creating a enforceable contract. So we will spend much time looking at offer and acceptance. And once that's been demonstrated, the next thing that has to be looked at is to ensure that there is certainty of terms. And then the third thing that has to be present in every contract is consideration. Those are the three main topics we're covering this semester. I mentioned last week that there are an additional set of enforceability issues or creation issues that sometimes arise. The capacity of the parties, intention to create legal relations. In some instances, contracts will, or an interaction between people will not be intended to be enforceable by law, but technically, if you looked at it, has all the elements needed to create an enforceable contract. So I don't know if I was telling one of you guys this, but a couple of years ago, there was some I'm going to insult him. I'm not going to insult this person. Okay. This person made this pitch like on some blog or something, or I can't remember where it was, about how he had matched with somebody through an online dating app, and they went out for a date and he paid, and that created an enforceable contract for the woman to go on a second date with him. And however, you know, this is probably somebody who was like in first year law school. He had like all the elements needed for an enforceable contract. I don't remember how, but clearly that's not a contract that was intended to be enforceable in law. So there can be situations, often between friends or between family members, where something looks like a contract, but it was never intended to be binding, to be a legal contract. And that situation is dealt with through the concept of intention to create legal relations. Unfortunately, we're not going to have time to look at that one because it doesn't arise so often. But that is another, so capacity, intention. And then the third one, as I've mentioned before, is that land contracts and insurance contracts need to be in writing to be enforceable under what's called the statute of frauds. So those are three other elements that can arise to challenge the enforceability, the creation of a contract, but we won't be learning them. I'm just flagging them for your knowledge in life. We're going to be looking at offer and acceptance, certainty, and consideration. So last class, we looked at the doctrine of certainty of terms. And so we saw that a contract must contain all essential terms to be enforceable. What an essential term is, are those terms that provide the core structure of an exchange. So essential terms are the terms that are needed to let the parties know what are their main obligations under the contract. Because if they don't know what their main obligations are, there's no way to know whether they've not performed it. Like how do they know when they're in breach, right? And then if, we don't know when someone's in breach and we don't know what they were supposed to do, how could we ever figure out what damages could lie for this breach? And so the underlying idea is if the parties have not come to agreement on these core essential aspects of the deal, how can we say they've actually come to a meeting of the minds, that they've agreed to bind themselves, when they actually have not agreed to very core aspects of the deal? So in that sense, certainty of terms, like offer and acceptance, are concerned with the issue of ensuring that there's been a meeting of the minds. As I've mentioned before, the meeting of the minds is not a standalone principle, right? You just don't walk in and be like, there's no meeting of the minds, the end, thank you. Rather, the concept of meeting of the minds plays itself out, is actuated through the principles of offer and acceptance and through the principles of certainty of terms, right? So if there is no certainty, there is no intention, right? If there was no offer, there is no intention to, or there's no meeting of the minds, etc. There are two situations in which a certainty issue arises. The first is, as we saw, vagueness. And the issue of vagueness is where a contract looks on its face like it has all its essential terms. But when you look at them a little bit more closely, you find that one or more of the terms are vague in their description. They don't fully explain what is required. And so that is what happens in the vagueness situation. In the situation of missing or incomplete terms, all the essential terms, on that situation, there is an essential term missing, one or more essential terms just missing. Either it's incomplete, like a formula that doesn't work, or it's just not there. Okay. Now, the same rules apply for both types of scenarios. It's just that some will be more relevant to one than the other. Like vagueness is not likely to, well, it could. I'm not going to make categorical statements here, but the idea is some of these principles may arise more in one context than the other, but they're generally all the same principles available to make arguments under each type of problem. Okay. Any questions so far? There's a big underlying tension, right, that animates the case law in this area. And that is, on the one hand, the courts say that they cannot make a contract for the parties. If the parties have chosen terms that are too vague or they've chosen incomplete terms, the courts can't come and change those terms. Why not? Why can't the courts change the terms that the parties have chosen? Genevieve?
Because it would take away the free will of contracting.
Yeah, like the idea is, as you'll remember, is that a contract is the product of the decision-making of two individuals or corporations, right? The state is not involved, and the courts are part of the state apparatus, right? The state doesn't tell you what you have to do, in theory, because it totally does, but anyhow, instead, it's the parties themselves choosing. And so the court's only role, they say, is to interpret and apply the terms the parties have chosen for themselves. So if the courts come in and change those terms, they're overstepping the bounds of their role. Okay. Now, again, as we see throughout the years, there's lots of ways in which the courts do more than just applying the terms that the parties have chosen. But this is an idea that is given a lot of lip surface. And this is kind of a theoretically important idea in terms of the what a contract is in a liberal market society. At the same time, though, often you will have situations where two parties really clearly thought they were in a contract. Sometimes they've been performing them for some time. So if you say they're uncertain, it's uncertain at this point, like the parties could lose out quite significantly. And so if we can give meaning to the terms, whether they be missing or vague, from the rest of the contract, we should do so, right? So if we can see, if something is, I think the example we use was defined as an emergency. And how do we know what an emergency is? Can we figure out from the rest of the contract what emergency was supposed to mean? If so, then we apply that meaning and there is no certainty issue. If not, we have a problem. So how do we go about thinking through an issue around certainty of terms? So you've gone and you've made your analysis of offer and acceptance. And at that point, you go back to the last offer that was properly accepted, because that's where the main terms of the offer is going to be, right, of the agreement. And you try and say, okay, well, what are the essential terms here, right? What is the nature of this deal, and what's a term that's needed to kind of make it operate? And then you ask yourself, are any of them vague or missing? You can also do it in the reverse if it's easier and say, I'm looking at these terms, are any of them vague or missing? And then ask yourself, well, is that an essential term or not? If there's an essential term missing, we want to ask ourselves, is there a workable formula or a mechanism that the parties have chosen that will allow us to give meaning to those missing terms? And then if there is a mechanism or a workable formula, or either a workable, that's fine, there's no problem. If there isn't, then a variety of specific principles arise, right? Is this an agreement to agree that we're dealing with? Is the contract completely silent on an issue like price? Is there a formula that doesn't work, but a mechanism that does, etc. So some of those more specific rules that came out of May and Butcher in particular arise at that point. If there is a vagueness issue and or there's no workable mechanism or formula, can the parties' intent on that issue be discerned from the rest of the contract, right? That's our next question. Can we figure out what it's supposed to mean? If no meaning is ascertainable, then the contract fails for uncertainty. A contract that fails for uncertainty is void. What that means is, in law, it was never created. So everything that's been exchanged, if the parties are performing, has to go back. Okay. Now, as a reminder, what happens if a non-essential term is missing or vague? Does that render the contract void as well? What happens in that situation? Andrew?
Could you just sever the term out of the contract to let the contract stand on its own?
Yes. And it's actually a good kind of test in the sense that if you sever this term, can the contract continue to function? If so, it's a non-essential term. If not, it's an essential term. Okay. Any questions here about certainty of terms and how this operates? Okay. Arshdeep asked in the chat, will we possibly have the chance to speak to Professor Aroka? Yes, I think we were trying to set up where she would come to our last class. I don't know how that lines up with your choice making, but how would Arshdeep, how would chatting with her affect your choice of in-person or online, do you think? Just so I can relay it to her to see if she can respond to that.
I hope you can hear me okay, Mike. I think talking to the professor might, I don't know, because for example, we spoke to Professor Tanovich and he's like, no, I'm not changing the way I'm teaching right now because online works better for me. So that's not, that class isn't available. So I just wanted to see what her outlook regarding that, like if she's kind of like waiting to see if a large number of the class wants to attend in person or if she's like
she's doing HyFlex.
Okay, like because I know you have, for example, you gave us that list of like your old like recorded lectures, and I don't know what the new professors like if they kind of do the same or if they're more like if they prefer in person. So like they're just their personal feelings regarding teaching. If they had a preference.
I mean, she's chosen HyFlex, so she's going to be in the classroom and is fine with people being online versus people in person. The whole idea of HyFlex is that you have the choice. She doesn't have recorded previous lectures, I'm assuming, because I did that specifically last year. She and I can discuss whether she still wants that available to you, but in the same way, the weekly classes will be recorded. So
okay, it's just because ILO currently I've been taking that in person. It's just been a little like too messy in terms of like how it's been going. That's why, like, if they had like a certain idea of what, it was just like it wasn't like anything specific, just to chat.
Yeah, I think she can, but I'm not sure it will be before the point that you have to make the selection because she was planning to come for the last day of class. I mean, I do get the sense that HyFlex may be messy, right? Because like everything my colleagues have said at every other university is that managing two separate constituencies is difficult. But given that some people do want to be online and some people want to be in person, you know, that's the best we've been able to come up with. So she is coming to class on the last day of class, but I don't know when you need to decide this by. Alexis?
I'm not sure if you'd actually know the answer to this. I just kind of thought about it when Arshdeep was speaking. If you attend in person, do you still have access to the recorded lectures if like they're on Blackboard or anything? Because I don't. Okay.
I don't know why there would be a difference. Like there's no particular reason to give it to online students and not in-person students.
I didn't know if it was something set up different on Blackboard or like if that's what she's using.
I think she would just be recording. She'll have a mic and it will be recording on Blackboard, but I'm not sure exactly. I don't know, like we haven't received all of the technical, we've been trying to be like, okay, what classroom am I in and what are the amenities and specifically what is giving, you know, because we all have to figure that stuff out too and not a lot of time. But that's the most that I know on that.
Okay, thank you.
No problem. Elizabeth?
Hi, I don't know if I missed this because my internet wasn't working at the right at the beginning, but will we have access to your Blackboard site still next term, even though you're not teaching us? Like, will we have access?
The materials will still be available to you, yes.
Okay, perfect, thank you.
No problem. Osama? No. I don't remember her. Ojan. Okay, I don't remember the first name. Sorry.
Hi, it's Ojan.
Yeah.
I just had a question. regarding the state of the contract. So you mentioned that if all that established, a contract will be void. My question is there any state in a contract that the contract is just ineffective? You know, it's not void, it's not in effect, but it's ineffective until a person who has the advantage makes a decision and, you know, just endorse it.
There's a concept of voidable. It's not applicable to certainty of terms, where there can be a problem with the contract and the party who is kind of harmed by it can choose whether to approve the contract anyways and keep going. And that concept will arise with doctrines that you learn next semester. So hopefully that answers your question.
Yes, definitely.
Thank you. Isabella?
Hi, this is sort of more on the administrative side of things. For our next semester's exams in April for this class, are they going to be cumulative? And if so, you know, should we be changing our approach at all to the material we've covered this term, if that's the case?
I don't know. That will be up to her, whether it's cumulative or not. But no, like we've taught, like the concepts are the concepts. The way of writing an exam and synthesizing is the same. And she'll have access to all my materials, so she'll see everything that I've given you. So she'll be able to figure that out. But I'm not sure if it'll be cumulative or not.
Thank you.
No problem. Other questions? Elena?
Just another sort of random question about switching over. I apologize. In your syllabus, the midterm is sort of like a fail-safe, and that if it's that will continue as well. Okay, perfect. That's my only other question.
Anyone else? Arshdeep?
This is regarding what we just talked about the steps. Would you be able to distinguish between step 3 and 4 again? Like I understand the difference. Like number 4, you kind of have to look at the rest of the contract to see if you can discern the intention about the missing or the vague terms, to see if like by that you mean the intention to contract, or are you talking about the intention in regards to those terms specifically? I just wanted to clarify.
Okay, I'll go over those again in a minute. I'm going to try and separate the like substantive questions and the administrative questions. So Mariam, what kind of question do you have?
This would be administrative, I guess.
Okay, go for it.
So I was just wondering for next semester, I'm not sure if you noticed this right now, but for all of the courses that are HyFlex, would we be required to go into Windsor if you're online to write the exam, or could we continue to write exams online?
I would assume not, but I don't know the answer to that. I'm assuming because it wouldn't really make any sense. But again, that's something maybe to confirm with the Associate Dean's office.
Okay, thank you.
No problem. Other thoughts or questions here? Okay, so what's the difference between step 2, 3, and 4? So at step 3, we're looking specifically at the issue of missing or incomplete terms to see whether we can resolve that problem of the missing or incomplete term from a formula that works or a mechanism that works, right? And we saw that there are a bunch of principles about, you know, if there's a missing price term and the contract is completely silent about price, both in terms of formula and mechanism, the courts can step in to provide a reasonable price. However, if there's a broken mechanism or a broken formula and it can't be given meaning from the rest of the contract, then the courts generally can't fix it, with the caveat that came from the case Sudbrook Trading that I talked to you about in class. So the point is that at step 3, you're looking to see, is there a formula or mechanism and does it work? And all the specific rules that arose in and around those 2 questions, right? At step 4, you're saying, okay, well, if there's a vagueness issue and or if there is no workable formula and or there is no workable mechanism, then can we nonetheless discern the meaning of the parties about what this term should have meant, or what the parties would agree this missing term, the content would be, or the etc., so that we can give effect to the contract. So one of them is looking at interpreting the rest of the document, and the third one is looking specifically at assessing the mechanism and formula and what options arise from that. Arshdeep, does that help?
Yes, thank you.
Oh, that's the end of certainty of terms. It didn't take us that long to go through, but of course it is relatively, it can be a bit complex in the little nuances of the rules, right? So you want to be able to have those straight in your mind. And then at the end of last class, we started looking at the doctrine of consideration, which we're going to look at further today. So we saw a definition of consideration being an act or forbearance of one party, or the promise thereof is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. Okay, on its own, that's a mouthful, but the idea is, I promise you an act, I promise you forbearing from acting, or I give you an act or forbear from acting in my offer, right? I say to you, I want to get into a contract with you and I will do this for you, either the act or I promise I'll do this for you. And I give you that promise to get the same thing back, to get something in return. So I give you a promise to purchase your promise or your act or forbearing from acting. What that means is both people must receive consideration, okay? And again, the idea is that the offerer is the person who's usually making the first promise, right? Because it's in the offer, right? In the offer, it says, this is what I'll do for you. And if it doesn't, then it's probably not an offer, right? Because it's indicating what is the exchange that's requested. And the offer will also often stipulate the return consideration, the consideration that the offerer is requesting, right? It says, you know, if you wash my car, I will wash your car if you do my groceries, right? I'm promising you that I will wash your car if you promise me you'll do my groceries, or it could be a unilateral offer, right? So I'm making you a promise so that I can purchase your promise to do my groceries. So each party is receiving consideration. And again, you're looking at the offer that was accepted, and that's where the essential terms are. And that's also usually where the consideration is stated, or the main consideration. The thing that can arise is it's often clear what is it that the promisor is offering, because it's in the offer. But sometimes it's a little bit less clear whether they're getting something in return. And so often it's clear what one party is providing, and we're really looking for the consideration to see whether they're getting return consideration so that we can say there was an exchange and the contract is enforceable. And the cases that we're looking at today give us a bunch of different scenarios in which, you know, one might ask oneself, are both parties getting something new? And we'll see how to reason our way through them. Any general questions about the concept of consideration before we move on? Brittany?
Hi, this might be like dumb of me to ask, but I know like for offer and acceptance, there were different rules if it was bilateral, unilateral. For certainty and consideration, it's just a general rule for both forms. Like there's no specifics for either kind.
Yeah, it doesn't matter. The issue is just identifying it. Like if it's a unilateral offer and I make you a promise in return for the act, then the consideration I receive is the act. It doesn't matter.
Okay, thank you.
right?
That helps so much.
Yeah, no problem. The last kind of general point to make, as I made last week or whenever life was last, is that the courts don't look at the adequacy of the consideration. They don't care about whether there's an equal exchange, right? In the Olteny days, they did. There was this concept of just price, and they would say, this contract is not enforceable because there's not a real kind of equal exchange. But with, again, the wheel theory of contract, the idea is the state was like, we're just going to create rules that permit you to do whatever you guys want, and you're equal in the law, even if you're not equal on the market, and you have the same rights. And so whatever you guys choose, if you choose to sell your house for $1, you can sell your house for $1, right? The idea is the court want to make sure there is an exchange, but they don't care whether it's equal or not, which is what gives rise to what's sometimes referred to as the peppercorn theory, which is kind of this idea that I could give you a peppercorn for my house, and the courts would enforce that. Okay. Questions here? Andrew?
Hi, is there an objective criteria that the court would use to determine if something is of value?
No, it's not, because when we say it's a value to the promise, the person getting it. So it's something they want. It's not an objective measure of like market value.
Okay.
Mm-hmm. Isabella?
This might be a more theoretical question. So, I mean, let me know if we have time to go through it. But the fact that the courts kind of stopped looking at the adequacy of consideration, do you think that that contributed to some of the way that larger corporations kind of get us into these contracts where we don't really have much of a choice and we kind of have to either forego the service or accept the terms as given? Would you say that that's a contributing factor?
So it's like, it's this specific rule, but it's more the interaction of all the rules that suggests that parties are just equal before the law in market relations. Because the problem is when we say that parties are equal before the law, it's kind of the same issue as like, formal versus substantive equality. That's great that we have the same rights, but the problem is we don't have the same market power, and we have no way in law to address that market inequality if it's only two parties who are equal before the law. And if we say, well, like it's all just a matter of your own choice, then what we're saying is, like, as long as you consent, it's fine. If your consent could be like coerced by market forces, you might have no real choice, but you always theoretically have a legal option not to contract, right? Even if it's not a practical option. And I mean, that's again, very core to the idea of a market, capitalist-based market, right? That idea that we're all out for ourselves. We all have the same power in law and the same choices in law. And it's not the state's role to intervene, although of course the state does intervene in all sorts of ways through tax rules and different incentives, right, about market power. But because we can't address that market power differential in law, then that allows a lot of the market differential to act without kind of legal constraint. I'm not sure if that answers your question, but Howard?
Yeah, how would that work in situations where you're gifting something then, where the contract is literally just, I signed the contract that I'll give you a house for free, but I'm not getting any consideration in return. So how would that work?
What do you think is the answer to that question?
I'm not sure.
Is a bearer promise enforceable?
No.
So unless you put that contract under seal or you give me $1.
Oh, okay. All right. Got it. Thank you.
Yeah, no problem. Okay. So let's take ourselves then to the case of governors of Dalhousie College and the Boutillier estate. And this case is kind of our main case, setting out the general ideas of contract, of consideration. So what happens in this case is that Boutillier made a donation, a pledge. He signed a subscription paper in which he promised he paid Dalhousie $5,000 for the purposes of enabling the college to maintain and improve the efficiency of teaching, new buildings, blah, blah, blah. Okay. And it said, in consideration of other donations, I make this pledge. That's what it said. And so in this case, what is Boutillier promising? Okay.
So he's promising to make that payment of $5,000.
Right. So we know what he's offering, right? We know what he's promising. What is the university promising? Howard?
According to the court, they're not promising, but then in a way they are using the money for buildings and the pretty much improving the schools.
Yeah. So the idea
obligated to.
Yeah, so the question is really like, that is the question of the case, right? Does the university provide Boutillier's estate with any fresh consideration? So in this case, Mr. Boutillier fell on financial trouble, hardship, and so he wasn't able to pay, but he said he still really wanted to, but unfortunately he passed away before he could pay. And so now Boutillier, the university, or the college at the time, I guess, is suing Boutillier's estate for $5,000. And so what's happening is the university is making a series of arguments to try and demonstrate that it did provide consideration to Mr. Boutillier. So effectively, again, in this kind of scenario, we're trying to figure out, did Mr. Boutillier just make a gift? Okay, or did he give his money to purchase something from the university? Okay. So the university makes three arguments here. The first argument they make arises from the language of the pledge itself. And it is the argument that each donor provided consideration in exchange for the donation of others. So if you promise to donate, I promise to donate. That would be the contract, and that would be both parties' promises. What does the court say about this argument? Howard?
That the promises is between the donors and not between Boutillier and the school itself.
That's right. So the court says, well, I mean, that could work between the donors. So if one of the donors was suing, maybe they could do it. But if there was that kind of contract, university, you wouldn't be part of it. So you didn't provide any consideration. They'd be providing each other consideration. And part of this is based on the doctrine of privity, which you'll learn next semester, which is the idea that somebody who's not a party to the contract, even if they benefit under the contract, cannot enforce the contract, right? So in this case, even if there was that kind of an exchange between the donors, it would be for the benefit of Dalhousie, but they wouldn't have given anything to Mr. Boutillier for it. So that one is not going to work. It's also slightly implausible. Like, I mean, I don't think, you could be in a donation campaign for a specific project where, everybody's kind of committed to that project and they're like, yeah, okay, I'll donate. Hopefully other people will donate. But in the average situation, like if you're giving a donation, I don't know, do you care about anybody else's donation? Like, are you really like, I would only give if other people give? Like, it's slightly implausible that that was the actual intent. So the next two arguments sound similar, but they're slightly different. And so the second thing the university argues is that although the subscription paper, which is the written contract, doesn't expressly ask, Mr. Boutillier does not expressly ask that the university use the money for the purposes described in the offer or in the subscription. That is impliedly what was happening when Mr. Boutillier gave this money. In other words, he didn't say, I'm giving you this money so that you undertake these projects, but impliedly that's what he was doing. And if that was the case, then that would be good exchange, because he would be saying, I'm giving you my $5,000 to get you to engage in these different projects, right? What was it, like building some buildings, updating teaching, keeping up with the times, kind of thing. What does the court say about this argument? Oh, hi, Harry. How are you? Yes.
Oh, fantastic.
You are actually coming in and out, Harry. I'm sorry. Do you want to put it in the chat? That's easier. No. Hi, Harry. Come back, Harry. Okay, somebody else answer, and then in Harry, in general, if you're finding it easier, feel free to put it in the chat. Otherwise, it's okay. You can give up for today and we'll figure it out. You don't have to keep trying to get yourself online. Jessica?
Awesome. Hi, Professor.
Hello.
So I believe what the court said in response to this argument that unless the promisor was getting something like specific from the gratuitous promise, there would be no consideration. And because he didn't, like, it was implied, but it wasn't explicit, there was no binding agreement that the school had to use that promised money for that specific purpose.
Yeah, that last piece is key. The text said of the pledge, says that he was giving the purpose, given the money for the purpose of enabling the school to undertake these projects. It didn't say so that they will do it, right? So they haven't actually bound themselves, obligated themselves to undertake these projects. And clearly they doesn't look like they'd want to. They've written this in quite general language. Maybe they want to use the money for something else. But their argument here, the court says, like, that doesn't work here because you didn't bind yourself to doing these things. You just wrote in permissive language. And if it's just permissive, then that it's not Boutilier's promise to give the money that has kind of pushed the university to undertake those projects, right? And so the court says there are situations in which we can kind of imply a request from the promisor, but those are situations where there's been like discussions between the parties about the money being used for something specific, and then the language is kind of enabling, but we could kind of imply from the interest of the individual in that project that that's what they wanted it used for. And that can also happen if somebody is very active in a specific project. So like if Mr. Boutillier had a long-term investment in the music department's development, and then there'd been a conversation saying like, okay, well, are you going to use this money for the music department? And then the subscription sort of said like, we have to use it for the music department. We could say in that situation, okay, we can see from here that actually the promisor wants this used for this specific purpose. We could imply that. But here there's nothing like that, right? There's no conversations about any specific use that he really wants this money for. This is a totally permissive promise, and which is not really a promise at all, right? Like it doesn't say we will do something. The university is not obligated. And they say you can see this because if Mr. Boutillier wanted to go and sue them if they didn't improve teaching with his money, could he have done so? He couldn't, because they haven't said that they will do it, right? So in this situation, the language is only permissive, and there's nothing to suggest, and that matters for two reasons. One is it suggests that there isn't a specific purpose that the Boutillier wanted the money to be used for, which again suggests that he didn't purchase a promise from them, right? And then secondly, it also that permissive language also just demonstrates that they haven't bound themselves in any way. The third argument is similar. Oh, sorry, Kavitha, did you have a question?
Yeah, I just wanted to kind of confirm. So basically the court said that they couldn't see that it was a type of implied request because there was like nothing to indicate that he implied specifically that his money would go towards those stated purposes that were written out.
That's right. And because they didn't bind themselves, like, so basically they're saying like, if there had been an implied kind of, we could be able to see that that's what he wanted them to do, then we could kind of change that permissive language and say, okay, well, yeah, it's just permissive, but you see, that's actually what he really wanted them to do. And so, you know, they're effectively impliedly binding themselves. But they say, well, but there's nothing here like that here. Howard?
Yeah, I'm just wondering, how should the university have worded it so that it would be a permissive language instead of using enabling? Like, what term should they have put in so that the court will find an enforceable consideration?
There's two ways of doing this. If, and again, you're like, hi, people, you have lawyers, what's wrong with you? It's not like these rules haven't all been around since 1602, but anyways, it depends on what the university wants. If it wants to be just fundraising to get general money and it doesn't want to bind itself, put it under seal, for God's sakes. Same thing with the Brantford Hospital people in the suggested case. You're like, hi, you've got like so many in-house counsel. Why are you guys doing shitty job? They didn't come out of Claire Mummay's contract law class, I can tell you that. So that's but if they wanted, sometimes, you know, you're fundraising for a specific thing. Like we are currently fundraising for the law school's new building, right? And then you would simply say, you know, I will give you this money to be used to, you know, work on this building. And then they would need to use that money to work on this building. So you would take out the permissive language and you would put in definite language, right? Must, will, etc., rather than can, may, maybe, enable. Those are good questions. And they're also things that you learn about in contract drafting, if that interests you for upper years. Okay, the third argument they make is that, okay, maybe he didn't ask for the money to be undertaken for anything in particular, but they did use his money for the things in the pledge. So like the language was enabling. They weren't required to do so under the wording of the pledge. And he didn't ask for something specific, but they did actually in the end use the money for those purposes. So can we say that, like, given that they did undertake those projects, that could be sufficient to provide good consideration? So the court says there is American case law to that effect, but we should not follow it. Harry, are you here? I feel bad. He was here for a second. Okay, so what else does does the court kind of comments and says, no, we have a problem with this approach. And is that similar? What's their problem with this approach, and where have we seen this kind of problem before? Why don't they think this can work, Jade?
Yeah, so the problem relates to the fact that there was no like evidence or anything that showed that the upgrades that the college did do since the promise would not have been done anyways if it weren't for the promise.
Yes. The aspect of it is more on the last part of Harry's comments here was that, well, but he didn't ask for them, right? There's nothing to show that's what he wanted, right? And they say, look, if you can have a situation where somebody makes you a gift, and it's a gift because they haven't asked anything for in return, so they're not giving their promise to purchase something from you, but you can rock up and be like, oh, we did some of the things that we were enabled to do, it's enforceable. You can force someone into a contract against their will. If what Mr. Boutillier was trying to do is just provide a gift, then the fact that and so he said, like, yeah, I'm giving you some money and you can do some stuff with it if you want to. The fact that they actually did it it doesn't mean that that's actually like he was looking to be an enforceable contract. And we know that because he gave his promise to purchase a promise, right? So if you could do that, then the promisee could unilaterally force someone into a contract. Somebody who was looking to make a gift could all of themselves find themselves in a binding exchange solely by the virtue of the promisee undertaking things that were only permissively permissive in the offer. Is this making sense to people? So it could be like, if I was like, I'm giving you my car. I'm totally not giving you my car, but I'm giving you my car and just give me a ride sometimes. And then I'm like, actually, never mind, I need my car, something big has come up. And you're like, well, I did provide you rides sometimes. So that is good consideration, even though you didn't like make that a condition of me giving you the car. And so that's an enforceable contract and you can't take it back. You can't take your car back, right? It would be the, and in the promisee transforming what was enabling into an obligation by their own act, whether or not that's what the offerer wanted, okay? And so the court says, again, like we've seen this before, we've seen concerns with this with acceptance of unilateral offers, of people performing the Acceptance Act without knowing about the offers. We saw this to an extent with the question of silence as acceptance, not wanting that so that one party could bind the other. And this is another instance of that. You can't just be like, well, I did the thing that I was allowed but not required to do, and that transforms this into a binding obligation. Because maybe the other party just wanted to give you a gift. And if it's a gift, it's not enforceable. They can take it back. Okay. Questions here? Kavita?
Sorry, this might be kind of a silly question, but I just wonder, would the situation like possibly be different in the case that he was alive? Like if he was alive and he were to like, and they were to kind of argue to be like, oh, we did it, so it's a contract, and he was to be like, no, like it's just a gift, would it, I guess that kind of like, yeah, it would still be the same, I'm assuming?
It's the same because it's just a matter of evidence. And as you remember, like we're looking at objective evidence, not what's in your heart, but how have you acted. And so here, by virtue of the fact that he gave money without asking for anything else to be done to get the money, is what indicates that he was making a gift. And what you can see here again is your promise has to be given to purchase something from someone else, right? So each party is purchasing each other's promise, which suggests again, like you wouldn't have been doing it if it weren't for the promise of the other. And the second part is that both people have to be bound. By virtue of this exchange of promises, they are obligated to do the things they've promised, or the act if it's a unilateral offer. They don't have the choice not to, right? So those are the two big ideas about consideration that come out from this case. So if you were going to tell me what is the legal principle or principles coming from this case, what would you say? What's the ratio here? Jessica?
So I think the ratio here was a gratuitous promise does not have sufficient consideration, that a promise that does not have sufficient consideration to be considered a binding contract unless the money was given for a specific purpose, which can be seen as some benefit to the promisor. And the promisee must rely on the actual actions of the promisor, not merely a statement that they will do something, and a bare promise unsupported by consideration is unenforceable.
Yeah, so the first and last things are the same thing.
Okay.
Yeah. And so I think that's right. I think it might be, you can tighten it a little bit to emphasize the key points, which is, again, a bare promise unsupported by consideration is unenforceable. It's a gift, right? And it's only where a promisor gives their promise for the purpose of gaining something from the promisee, and both parties bind their future course of action through a return promise or act. so as to purchase the promise of the first, that we can say both parties have received consideration. Again, the two underlying idea is I give my promise to get a promise from you. So I'm asking you to bind yourself to something. You are binding yourself to me to get my promise for you. And both of us have to now be obligated to do the thing that we've promised. Okay. Questions here? Becky?
So can the promiser get their money back once they like promise that they'll give a certain amount of money? Like they already gave, like, for example, the college the money. Could they ask for it back if they did?
No, well, not easily, I don't think. But like there are mechanisms by which they might be able to, and there might be principles around there. There's a well, I know in the example I just gave, I gave you my car and then I took it back. That's not a good example. It would be like if I took it back before I gave it to you. So yeah, does that answer?
So legally, you're entitled to
You
whatever.
can give a gift, right?
Yeah.
You can give a gift. It's just that I guess it's a little bit more complicated because it sort of depends on the thing and how, like, different things have different rules about like how the property right is moved to another person. So if I want to give you my car, I can like sign over the ownership cards to you and then that's it, right? But if I make a promise and I want to renege on it, I can do that too, because I'm just giving you a gift. Does that answer?
So there's an execution element to it?
Yeah, but again, it also depends a little bit, like there's some things where there's an act you can do to transfer ownership to another person. And so once you've done that, that's then binding. But then there's other things, like if I give you my coffee mug, well, have I transferred ownership of it to you? Those are based on property principles. Does that make sense?
Okay, yeah.
Okay.
Thank you.
No problem. Arshdeep?
I'm sorry, just to confirm like my own understanding of this in a different example. So pretend that there's someone and then they're like, okay, you can come, I have a house and you want to move here and you can come stay in this room. And then they're not like asking for anything in return, or there's no reciprocal action there. And let's say you go there and then you stay there and they're like, actually, never mind, you have to leave. The person that's there, they can't really, it's not an enforceable contract because technically speaking, the other person not receiving any consideration for it. But for example, if I was like, oh, I'm gonna stay here and I offer like I'll walk your dog or something for you, that would be an enforceable consideration in that sense.
That's right. And the difference between that situation and the car is that like I haven't, like with that one, they haven't like transferred property ownership of the thing. Whereas if I gave you my car and I transferred the ownership, I wouldn't really be able to just ask for it back because I have gone through a government process to give it to you. I hope this makes sense. Whether you can take it back or not depends again a little bit around property rules of ownership transference. JD says maybe more like I'll pay for your gas every week, just give me a ride sometimes, and then just kidding, I don't have gas money. And they say, but I gave you a ride to work yesterday, so you owe me the gas money. I think it'd be the other way around, because one person has made the promise, I'll pay for your gas every week. It's the other one, just give me a ride sometimes, that could be reneged upon. JD, if I'm understanding your example. Andrew?
I'm just a little bit confused with regards to the Brantford Hospital case.
Mhm.
So would the promisor, even if something is done for their benefit, would they have to explicitly request it being done? So I'm thinking about, they named the wing after the lady and her deceased husband, but I think the principal in the case was that she didn't request it outright. Am I following that correctly?
It's not that it has to necessarily be expressed, like we can imply from the circumstance that that's something she wanted. The issue is there's nothing to suggest she cared about having a hospital named after her. It was the hospital's idea, right? Which comes back to the situation where have I given you something to get something from you, right? Because otherwise we're kind of looking at two gift situations. We haven't purchased each other's promises in that sense. It wasn't something she wanted. In which case it looks like she was just trying to give them a gift.
Got it. Thank you.
No problem. Other questions here? Okay, so I think I mentioned this briefly last class, but there is this idea of illusory consideration, and it follows logically from the analysis in Boutillier. And that is, if I make you a promise, but actually I retain sole discretion about when I exercise my promise or not, or whether I exercise my promise or not, that is what we call illusory consideration, because I haven't bound myself. So if Rogers says, we reserve the right to change any term in this contract at any time at our sole discretion, what have they promised me they're going to do? Nothing. They're not bound, right? There's not obligations that they are required to undertake on the basis of that promise. So in any situation where one party retains full discretion as to whether or not they will perform an obligation, that is what we call illusory consideration. Like if we say, I will give you gas money if you give me a ride sometimes, right? That example. Well, I get to decide whether I give you rides sometimes or not, right? I haven't obligated myself to do so. It kind of looks like consideration when you look more closely, you see actually they haven't obligated themselves to do anything. And that's called illusory consideration, and it's not good consideration. Andrew, do you have an old hand up or a new hand? Old hand?
Sorry, that was an old hand.
No problem. Isabella?
So I'm kind of struggling to wrap my mind around how illusory consideration works in terms of a unilateral contract, because that feels like until you're done the act, the promise is illusory. Is that,
It's not illusory. It's like you're not making a promise, right? You're doing an act. So it would be more about whether the promisor's consideration was illusory. If it was like, I might pay you if you cross to the other side of the bridge. Well, I might pay you. Are you going to pay me? Or I promise I'll pay you if you walk to the other side of the bridge if I feel like it. I mean, it's not exactly the wording it would be used, but in that case, it's the promisor's consideration that could be illusory, not the promisee's, because as you say, the consideration is the act. And given that you need to give the act to perform with a unilateral contract, the promisee, the offeree, is giving consideration. The question would then be if they're getting any. Does that answer your question?
Yeah, that makes a lot of sense. Thanks.
Yeah, good point. Elizabeth?
The example that you just gave about crossing the street, it seems to me, I don't know if I'm not understanding it properly, but it seems very similar to like vagueness in terms of certainty of terms, like a vague condition.
It can be, yes. And so this may happen so it cannot bring up the same issue. You could be saying, and also you could say, well, was that even an offer? Okay. So you can have situations where something is vague and then it makes you wonder, well, was there an intent to be bound? And then also can we find meaning for this? And also, have you actually bound yourself? So that can happen in some instances where it hits those similar issues because it's similar questions underlying each one of these doctrines.
So there can be overlap between illusory consideration and vagueness, for example.
Sure, there always could be, right? Like again, if it was like I used in an old exam, oh, you have to come work in emergencies. If you haven't defined emergencies, then who decides if it's an emergency, right? And so that's a certainty issue, but then it also means who have I bound myself to do that if I don't know what is the obligation? So it depends. It won't always come up at the same time, but it can.
Okay, thank you.
No problem. Okay, Isabella, I'm lowering your hand, and Elizabeth too. You can re-raise it if you have a feeling. Okay, it's a good moment to go on our break. When we come back, we'll look at sort of different specific types of consideration issues. All good? Okay, come back at 3. Goodbye. Okay, everybody, let's get started back. So we left off by talking about the concept of illusory consideration. And I just wanted to make a general note of clarification, which is that in any given contract, the parties can exchange a number of things, right? So there often isn't one consideration. There's a bunch of promises that you're making to someone. If you're in a construction contract, right, the construction team is making a promise to do a whole host of things. Not all of those will be essential, right? And in the sense of an essential term. But there's many things that often we promise each other a number of different things. And the way the courts think about it is a contract will be enforceable so long as there is some, like one consideration, some consideration. So even if a court finds that a bunch of, there's like two provisions that are illusory consideration and not enforceable, for instance, so long as there is one promise that's purchased by the other, and there's something that the parties are obligated to do, then that's enough to render the contract enforceable. So in more recent years, what, like large companies like Rogers will do is they will say, we promise we will give you 6 weeks notice if we're making any unilateral changes to the contract. So there's one thing they're required to do. They are required to give you notice of a change. They can still make their changes whenever they want to, but there's one thing they're obligated to do. Sometimes there's more. But as long as there's one thing they're obligated to do, that is enough to render the contract enforceable. Okay. Questions on this point? Again, for your knowledge, this isn't testable, but just so you know, there are some situations in which the contract won't expressly stipulate an obligation for one of the parties, but the implication from the conversations between them and or the circumstances, it's clear that even if imperfectly expressed, that party has taken on an obligation. In some cases, the courts will imply consideration. I don't test on this one because there are a bunch of rules about when a term can be implied into a contract, which will be used in this situation, which we're not dealing with at this point, okay? But just so you know, there are instances in which consideration can be implied, where it can be that obligation can be discerned from the rest of the undertakings between the parties. Okay, so our next few issues are specific facts and fact situations that either do or seems like they could raise consideration issues. And so we're going to look at these different fact scenarios. And what's really important with each one of these is to be able to identify in what factual situation each one of these issues will arise, so that you can A, tell me on an exam that it exists on the facts before us, and B, know which principles guide that situation. So as a caveat, of course, in an exam, given that we need there to be offer and acceptance, and there needs to be certainty, and there needs to be consideration, you're always going to have to tell me what is the consideration exchanged between the parties. Sometimes it'll be relatively straightforward. Sometimes there may be arguments about it, but you have to show me it's there or it's debatable, right? Without showing that, the contract can't be enforced. So, give us the principles from Boutillier and say, when X promised to do Y, you can see it was purchased to get the return promise of Z, etc. Okay. So similarly, if any of the next kinds of factual scenarios arise, you want to be able to explain to me why that issue is there on the facts, so that we can then know which principles apply to that situation. So the first one we're going to look at is what's called past consideration. So past consideration arises when someone gives you something or does something for you, and then it's only after you get it that you promise that you'll pay for it, right? So in this kind of a situation, you ask your friend whether you can borrow her car on Monday afternoons. She agrees. So you use the car for a few weeks, and then you say, oh, I'm going to pay you back the gas, money for the gas I've used. Well, is that an enforceable promise, or is this effectively two gifts? That's the question of past consideration. So again, past consideration arises where somebody confers a benefit or makes a promise to the other, and only after the person who benefits receives the benefit or the promise do they then promise to compensate for it in return. For some reason, it like whenever I project any of my graphs or my like little images with its shapes, that everything moves when it's in Google Slides. It doesn't move in the original, but it does in Google Slides. So again, it's a situation. Person B provides a benefit to B. Here's my car. You can drive it on Monday afternoons. And then after B receives the benefit, then they make a promise in return. This is different from the normal situation where promises are exchanged before anyone has to do anything, right? So usually we would say, I will lend you my car on Wednesday afternoons if you give me the gas money that you spend, right? That's what we would usually do. So the promises would be exchanged prior to their performance. But sometimes this past consideration arises where one promise is made or one act is conferred, and then only after it's received is there a promise made in return. Why do you think this could create a consideration problem? Alexis?
I don't think at this point there's a meeting of the minds because they didn't make that agreement based on the promise that somebody else was giving. So there was no consideration. It wasn't a promise for a promise at this point. It was just here, use my car.
And what would we call that? I know that's quite a general question, but if I just make you say, here, use my car, what's that?
A gift.
It's a gift. And then, as Prashna says too in the chat, then if I say, oh, I'm going to pay you back for the gas money, am I saying that to get your promise of lending me the car? No, because I already have it. Right? So it looks like I'm not giving my promise to pay to get the car. I already have the car. It looks like I'm giving a return gift as well, right? The promises don't look like they're purchased for each other. They're not given to get the other thing. They're each just promises, or sorry, gifts, right? Questions so far? Are we understanding this scenario? So if I provide you with a benefit, I lend you my car, I don't ask for anything in return. You get it, and then later you're like, oh, okay, well, I'll pay you for that. When I lent you my car, it looked like I just lending you my car, right? I'm just giving you a gift. I don't ask for anything in return. And when you have it, and then you later promise to pay or compensate in some fashion, you're not giving your promise to purchase the right of access to the car because you've already had the car, right? And so you are also look like you're giving a gift. So the past consideration issue brings up an issue where it looks like, yes, there is an exchange, but neither is given to get the thing of the other. And for that reason, it looks like two gifts. Okay. So the general principle comes to us from Eastwood and Kenyon. And the rule there is, the general rule is that past consideration is no consideration. Right? If acts are undertaken voluntarily and gratuitously without the request to receive payment in return, then the first promise is a gift. The promisee's subsequent promise to pay may also be a gratuitous promise because it's not given to get the first person's promise because they already have it. Okay. And this is why neither party is making a promise to purchase a promise. It looks like both parties are making a gift. Okay. Questions about this? Okay. So again, in any given scenario on an exam where you think a past consideration situation arises, you have to show me that it exists on the facts. When Harry, provided a benefit to Sally, that looked like a gift because Harry didn't look for anything in return. And then when Sally said, oh, you know what, I'll give you this other thing. Well, she already had the benefit of his gift, so she wasn't making it to purchase the promise, right? So you have to tell me on the facts why a past consideration issue arises. And then, of course, in your synthesis, you are explaining the purpose of the rule, right? And the rationale here is that this looks like two promises. So you would be explaining why this looks like two promises. Alexis?
Just for clarification for me to see if I'm getting it right here, would it be like when you go sometimes to like Italy or something and they're giving out those like roses and they hand it to you and it's like, no, you don't have to pay for it. But then it's like when they give it to you, it's like, yeah, no, you have to pay now for it. Is it kind of like that where that was a gift and now they're trying to like push you into it? So it can't be consideration because.
Yes. So let me give you this scenario. It's kind of like the one you have. I may have told you it before because I'm still really angry about it. So I was in a car accident and there was my back bumper was just crumpled in. And so I called the insurance company and they said, go to this body shop. So I do, and it's raining. So we walk out in the rain and I'm like, yeah, it's the right side bumper. And they go, okay. And then like 3 days later, they call me and they're like, there appears to be a mistake. So they did the front right side bumper, but I was talking about the back right side bumper. Now, I thought that was obvious because one had some little scratches and the other one was completely crumpled. But anyways, I had actually like clearly explained it and other things. Like it was clear it was their mistake. But they were like, well, we've spent this like labor and it's cost us this paint. And so we think you should pay for it. And I'm a really good lawyer for other people, but I'm a shitty lawyer for myself. And so I was like, feeling all pressured. And I was like, okay. And I was like, what the hell? Like I wasn't planning on fixing those paint scratches at all. And that this was going to be, I don't know, like $500 or something. And when I went to pick up the car, there was no bill for the mistaken bumper. So I thought, oh, okay, they came to their senses. And I left. And 6 months later, not even like that week, 6 months later, I get a bill. I'm like, oh, you haven't paid us for this. And I was like, okay, this is ridiculous. Like, yes, I said I'd pay for this, but you didn't even charge me. This is all your problem. And they're like, we're going to send you to collections. And so this is an example of the real life of contract law, because the companies have a right to enforce they can enforce their version of your contractual relations by sending it to collections. And then it's the consumer's job to disprove, right? To convince the collection agency and or go to small claims court to dispute what the company decides is the analysis of the contract. So then I was like all pissed off and trying to decide if, and I started to write out all these submissions and I was like, I don't have time for this. So I paid it, right? But I did not have to pay it in law. I was like, I'm a lawyer and here are all the ways. And he's like, fine, go tell that to the judge. And I was like, you are a dick face. That's what I thought, sorry. But I have a strong legal argument about why I didn't have to pay for that bumper. And what is my argument? When did I make a promise to pay? Nathan, this was past consideration. Yes, why? Harry.
Yep. Can you hear me? I think my internet is doing better now.
You must be so stressed.
Yeah. So in this case, you had already received your car and you already paid for what you, I guess at that point, assumed was the entire fee. So you'd already received your car. So that would be the promise to you, the benefit that you're receiving. So 6 months later, they can't say, oh, actually, you owe me $600 or you owe me $500 for the car that we give you back. At that point, it would be past consideration, not applicable.
Yeah, like I made the promise to pay, quite soon after getting the benefit, but still I made that promise after I already received the benefit of the fixed bumper. So they conferred something on me, and then I later promised to pay for it. So what you can see is that the general rule of past consideration actually protects two situations. One is where two people have made a gift to each other, they haven't purchased each other's promise. And the second is when someone's kind of forced something on you and then gets you to try it, convinces you to pay for it, right? There's a kind of similar idea than the one in St. John Tugboat, right? You can't just kind of force someone into a contract by doing some stuff for them and being like, okay, pay me, right? It's a similar rationale here. So in this scenario, this was clearly past consideration. Now, there is an exception to the rule of past consideration, and that is what is discussed in our fave case, everyone's fave case of Powon. So the idea is we have this general rule, right? Past consideration is no consideration. We know why we have that rule, when it would be applied. But once in a while, you have a scenario where the issue isn't that two parties have made a gift to each other, but it's just that the promises have happened in the wrong order. So if I had said to, if I had said to the Fix Auto, like, oh, can you fix my front bumper? And then they fixed the bumper, and only after did I say, I'll pay for it. That would give rise to a past consideration issue, but that seems kind of unfair, right? It's clear that this was something, it would have been clear that this was something that was intended to be paid for. And it shouldn't be that just because the promise wasn't made before the benefit was conferred, that it shouldn't be enforceable. And so in the decision of Powon and Lau Yulong, they set out the situation in which past consideration can be revived and considered good consideration. So the case of Powon gives is a very complicated fact scenario and like all very corporate. And I remember in law school being like, share purchases, what are you, Google, with this case. So it's like a rite of passage to try and figure out what happened in this case. But in Powon, they speak to two different legal principles around consideration. So we're not going to do the whole case together right now. We're going to look at the rule regarding past consideration, and then we'll come back to pre-existing contractual duties to a third party in a minute. So hopefully my fact summary gave some understanding of what happens in the Powon case. I can go over it again now. Do people feel like they kind of understood what happened? Yes. Do you want me to do it over again? Some people do. Okay. So the one thing to keep in mind with Powon is the facts are very specific. And so you're not going to likely be analogizing or distinguishing to the facts of Powon, right? The idea that there's going to be like a contract and one subsidiary agreement and then another subsidiary agreement and like promises made in three places, like this is not likely going to happen again, right? So focus on the principles that were used and how those tests were applied, and that might help a little bit. Okay, so what happens is the Powon family, or the Pow family, were the owners of a company called Shing On, and Shing On owned a building. So this was in Hong Kong. The Food Ship company is a publicly traded company. Shing On was not, it was privately owned by the, I believe. So Food Ship wanted to acquire the building owned by Shing On. And Food Ship was majoritively owned, its shares was majority owned by two brothers, Lau Yulong and I believe Benjamin Lau. So they came up with a contract in which the shares in Food Ship are exchanged for all of the shares in Shing On. And so this contract is made without the exchange of money, which is what makes it a little bit more complicated. So what happens under the main contract is that Fuchip buys all the shares in Shingon. I guess it's not privately owned, which are owned by Mr. Pao and his wife and son. And in doing so, they acquire Shingon's building. So in exchange, the Pao family acquire 4.2 million shares in the Fuchip company. So they exchange shares in companies, right, as payment to each other. So there's a main contract between Mr. Pao and the Fuchip company, right? Because companies have independent legal personality if they're incorporated. So they're treated as a human, as a person in law, which is totally weird, but you could learn about that in the future. So there's one contract, main contract between the Pao family and the company Fuchip. And one of the promises that are made here is that the Pao family will retain 2.5 million shares in Fuchip for a year. And the idea is that the Lau brothers were concerned that if the Paos acquire all these shares and start speculating with them, it would create some investor disquiet, right? They always talk about like investor confidence, just so weird. Who are all these investors? Why do we care about their psychological confidence? But in any ways, so there was concern that if they did that, people might get concerned about the health of the company and the value of the shares would drop. So they said, okay, we'll do this exchange of shares, but Pao family, we would like you to retain the shares for 1 year so we can avoid this confusion on the market. And the Pao family said, fine, but like what happens if the price of the shares drop after a year? Then we'll be at a loss. So they created a first subsidiary agreement. And in that agreement, Benjamin Lau and Lau Yulong agreed that after the end of the 1 year, they would repurchase the 2.5 million shares at a price of $2.50 a share. But Mrs. Pao realized sometime thereafter that this was not a good deal for the Paos because it would protect them if the value of the shares dropped. But if the value of the shares had risen above 250, they wouldn't be able to sell it on the open market and get that increased price. They would be obligated to sell at 250 regardless of whether the share prices had risen. And so again, they would lose out on the possible benefit of acquiring these shares. And so the Pao family refused to go through with the main contract unless a new contract subsidiary agreement was made in which there would just be an indemnification or guarantee, which meant in this context that the Lau brothers would repurchase the shares at 250 if the values of the shares were below 250, and if they were above 250, they could just go sell it on the market. So they'd be able to get the benefit of the increased price of the shares, but not suffer for any drop in price. Now, the Lau brothers could have just sued for breach of contract. They could have said, you know, the Paos are refusing to go through with the contract, they're breaching it, you know, we have an agreement, promises were exchanged. But the practical realities were such that they had just announced publicly that Fuchip was acquiring Shingon. So if they started a lawsuit, that would not only look, again, not great for the health of Fuchip, but also it would take a long time, right? And so the Lau brothers decided that they would agree. They would make a new subsidiary agreement in which they would indemnify the Pao family. So what you end up with is two contracts, sort of. There's a contract between Paoan family and Fuchip, and there's a contract between the Pao family and the Lau brothers, okay? Because it's the Lau brothers who personally indemnify, guarantee the share value after a year. This first subsidiary contract is repealed, and in its place is this second one, right? So the Pao family are in a contract with two different parties, with the Lau brothers and with Fuchip. Okay. Any questions so far? feel like there are. But, okay. So the Lau brothers say this is a situation of past consideration. And as Eastwood and Kenyon tell us, past consideration is no consideration. And therefore, this second subsidiary contract is not enforceable. Because I forgot to say, at the end of the 1 year, the price had increased in the shares and the Lau brothers refused to, or they had dropped and they've refused to protect them. Harry?
Oh, sorry. I was just going to comment on the shares having dropped.
Yeah. Okay. So where's the past consideration issue here? Somebody try it. Jessica?
From my understanding, the past consideration part came in at the simple guarantee, or like the second subsidiary agreement, where I think it was Miss Lau wanted the simple guarantee that the shares would hold their value. And so because the Lau family worried about the loss of confidence, they agreed into a new subsidiary contract specifying that in consideration of the Pows having agreed to sell their shares within the year, if they drop below 250, then they would pay the difference, or they would be able to get the benefit if they were above market value.
So what is the past, so that you're right, the past consideration issue is around the second subsidiary contract, but how is there a past consideration issue here? Kavitha?
So what and I don't know if I interpreted it correctly, but what I interpreted it to be was that the consideration was part of the original contract. So when the Pows agreed that they were going to keep the 2.5 million shares for a year in benefit of the Laos, the promise made in return was that they would be protected by in some sort of way if those shares were to decrease in value.
Yes, but so again, where's the initial benefit of the act and later promise in this scenario? Someone try. Jessica?
Oops, sorry, I forgot to put my hand down there.
Okay.
I'm not quite sure on that
one. Isabella?
Yeah. So I'm not 100% sure about the past consideration per se, because to me it kind of feels like they tried to renegotiate. It sounds more like even though the contract kind of already started, and the performance was kind of starting, it didn't, I don't know, maybe I'm way off on this, but it feels more like a renegotiation to me. Would you be able to explain why it's not?
It is a renegotiation. They unmade this contract and made this one. Okay, but there's still a past consideration issue here. Harry?
So from my understanding, the past consideration would be the addition of the terms, because the Powell family is agreeing to retain the 2.5 million shares. And the understanding there was that it's for the purpose of the Laos would buy it back 250 share. That was the original agreement. So when they added on the part where they would indemnify them if the stocks drop in value, or the shares drop in value, that would be sort of the catalyst for the past consideration. That's sort of like a gift that they're giving at that point for what was essentially a contract already outlined.
So you're saying it's between these two contracts that there's a past consideration issue?
I mean, just contract, the original contract and the initial subsidiary are the primary contract, and then because they're tacking on the indemnifying part, that would be the reason why there's past consideration, because that was not a part of the original discussion. Like in the same way that after the fact you can say, "Oh, I'll pay you for gas," the 2.5 million shares being indemnified, that's kind of just being tacked on.
I can see why you would think that, but it's not that. But I can see why you would go there. Genevieve?
Actually, I thought I had the answer, and now I feel like I've gotten confused, but I think I'll just try it. I think that so initially, so the Laos already have the benefit of knowing that the shares will not be resold. And so then them making the promise back to the Powell family that they will like indemnify them is just like a gift. Like it can't actually be held in law.
That's right, right? So the argument is that under the main contract, the Powells were already obligated to retain it for the shares for a year. And so they say the Lau family, like, we didn't get any fresh consideration because you were already obligated to do that. So they're obligated here. A benefit has been conferred. Okay. When the Laos promised to pay for it, they're making that promise after they've received the benefit under the first agreement to retain the shares under 1 year. So they're saying their promise isn't enforceable because it's past consideration. Okay, we understanding this idea, right? The idea being that what it was in this second subsidiary contract as it was in the initial contract, and this one's just repealed, right? So it's not changes between these two that matter. It just complicates our lives. The idea is in this contract, the agreement is you'll retain the shares and I'll pay, we'll indemnify you, but they already had the benefit of the promise to retain the shares from the initial contract, from the main contract. So that's their argument. When we made a promise to you to pay for it, we already had the benefit of your requirement to hold the shares for a year. Okay. The court says, yes, when there's a past consideration issue, then past consideration is generally no consideration. They say, however, it is possible sometimes to revive past consideration. And when that happens, the revived past consideration is now.
Hi, I was wondering if I could book an appointment to get my hair done.
Alexis,
No.
You're not muted. It's important to get your hair done. This is the dangers of online teaching. In any case, totally can see myself doing the same thing. So what Lord Scarman says is sometimes you can revive past consideration, and that happens when three conditions are met. So they say when the act, in this case, the retention of the shares, is undertaken at the promisor's request, and the promisor being the person who later makes a promise to pay here. So in this case, the Laos. The parties must have understood at the time of the initial act, at the time the initial benefit was conferred, that it was one that was going to be compensated. And 3, if the promise to pay for the benefit had been made before the act was undertaken, it would have been legally enforceable. So we'll come back to this last one in a second, right? So if we go back to our previous scenario, you ask your friend to let you borrow her car on Monday afternoons after getting the benefit you promised to pay, right? Our general starting point, this is past consideration, which is no consideration. Was the act done at the promisor's request, right? So was your friend's promise to lend you the car done at your request? Yes, it was, right? Like you asked, could I borrow the car? Was this something the parties understood was going to be paid for? That's not clear here, right? It's not clear that this isn't just a gift, that this was something intended to be paid for. C, the idea is if she had promised to lend you the car and you had promised to repay the gas money before she lent you the car, would that have been an enforceable set of promises? And the answer to that is yes, right? So if the promises had been exchanged prior to the act, it would have been enforceable. This last step is also where, so basically this last step asks, if the promises had happened in the right order, if they had been exchanged prior to the benefit being conferred, would that contract have been enforceable? which means that if there are any other issues other than past consideration with this exchange, it's illusory consideration, there's a certainty of terms problem, etc. You can argue that at step 3, okay? So the idea is that we are asking, was the act conferred at the promisor's request? Did the parties understand it to be compensated for? And would it have been enforceable if the promises had been exchanged in the right timeline? So if we go back to my car situation, was the car bumper fixed at my request? No, right? Was this both something we understood at the time of the initial act would be compensated for? Well, usually I understand that if a car company fixes something for me, it's to be paid for. However, I never asked for it. So no, at the time of the initial act, this isn't something that we both understood should be paid for. But if I had promised to pay for it before they fixed that bumper, yes, that would have been legally enforceable. So because step 1 and 2 aren't there, in my situation, the past consideration could not have been revived to make it good consideration. And what you can see again is that this test is designed, the revival or the general rule and the exception are designed to protect in 2 different situations. The general rule protects in situations where the 2 parties made a gift to each other, but weren't wanting to be bound, and a situation where somebody's given you a benefit that you never asked for or wanted, okay? In those situations, past consideration is no consideration. But in situations where the promisor did ask for the thing, and it was something that both parties understood was to be paid for, even if the promise to pay didn't come till later, well, we should say that that should be enforceable, right? Because we all understood this was something to be paid for, but the promises just happened in the wrong sequence. Okay, so in this case, they say, was the act of retaining the shares for a year, was that undertaken at the Lau's request? Yes, it was. Did the parties understand that the retention of the shares was something to be compensated for? Yes. From the beginning of this interaction, it was clear that the Powell family were going to need some kind of protection, something in return for their agreement to retain the shares. If the promise to retain the shares and the promise to indemnify had happened at the same time, as it did if it had just been the initial subsidiary agreement, it would have been enforceable. In this case, the past consideration should be revived because everyone knew that the Powells were to be paid for this thing. And as such, this isn't a situation where 2 people made each other a gift. And it's not a situation where someone was given a benefit and later tried to be pushed into being paid to paying for it. And so we should enforce this agreement. So when it comes to past consideration, we have 2 rules, right? Past consideration is no consideration, and an exception where it can be revived. So again, on an exam, if you can make an argument, if one party can demonstrate there's past consideration at issue, the other may try and argue that it can be revived. Sometimes that'll work, sometimes it won't. It based on the 3 steps test for revival from Powell on. And of course, you're always thinking about the underlying purposes of these 2 rules to say, does my fact situation look more like the kinds of situations past consideration protects against, or does it look more like a Powell situation where things happen in the wrong order, but everyone knew this initial benefit was to be paid for? Questions? This is making sense. Kavita?
Yeah, okay, so I just had a question. So if you were given a situation and you had to, argue on like this is more of like a hypothetical question rather than for the exam or anything like that. So if you're given a situation and you and it was kind of clear that it was past consideration and objectively you probably know that the general rule would apply, so past consideration isn't good consideration, would you still try and find any way possible to make it seem like it can fit within those 3 rules, or like
You
I
would
think
just say, like on an exam, you would just say, there is an exception to the general rule, but, and here is the exception, here's the 3 steps, but in this instance, it wouldn't work because it didn't come at the promisor's request, and it wasn't intended to be paid for based on these 2 little facts, you know. So it's the same as the sort of raise and dismiss, like, I see you, this is why it doesn't apply.
Okay.
And the reason, you know, like sometimes I said, like, if it doesn't arise at all, don't raise it. But there are things like that go together. Like if there's a past consideration issue, people are going to be like, well, can it be revived? So people's brains will automatically go there. So it's just useful to tell them, you might think this, but no. Okay. Okay. Any more questions about past consideration? Jessica.
Just a quick clarification. So it's a past consideration, but that past consideration stemmed from the initial agreement or the initial consideration. And the only reason why it's like past is because the act of the consideration was to come at or the completion of the promise was to come at a later date.
So this is kind of like, they're trying to say it's past consideration. It's a little bit unwieldy in this circumstance, right? Because they're saying that because in the main contract there was a promise to retain for a year, when that same promise is made in the second contract, like the Laos already have the benefit of that, not because it happens, they're making a promise a year later, because they're not. It's because that was already owed under the first contract. I'm not sure that's really a past consideration issue, the facts, but the court's kind of like, it's, yeah, okay, fine. But anyways, it's revived, right?
Okay.
Ordinarily, it would be once you have the benefit of the act, like once you have the act. What they have is like a binding obligation that the act will be undertaken. Okay.
Okay, cool. That makes sense.
Yeah.
Thank you.
No problem. Okay. Our next issue. So we're going to look at 2 other types of consideration issues. They have confusingly similar names. Okay. You have to separate them in your brain because otherwise it's very easy to think they're the same thing. So 2 things here. The casebook looks at a whole bunch of issues, has a general concept of well, I can't find it, of pre-existing duties. Okay, they have this general concept, and they put a whole bunch of things under there. But I find that confusing. So I'm giving things more precise terminologies. The idea of a pre-existing duty in general is, do you make a promise to someone in a contract that you're already obligated to undertake? Okay, so that can give rise to different situations. It can arise where there's like a public law duty to do something, where there's like a statute that says, you know, I don't know, maybe there's a municipal bylaw that like people have to get the leaves off their front property. If I then promise my neighbor that I'm going to clean up my yard if they do something, I'm under a pre-existing legal duty to do that thing. In the same way, if we're in an existing contract and we try and change the terms of the contract, there's a pre-existing legal duty, contractual duty from the initial contract. Pre-existing duty situations arise when one party promises to do something in a contract they're already obliged to do from a variety of different sources. But I am trying to give them more precise terms so that we don't have, so you know exactly which issue we're dealing with. So a lot of the things that are considered under the topic of pre-existing legal duties are contractual variations. I'm going to give them that title to distinguish the factual scenario. Okay, so we're going to look at third-party consideration, and then pre-existing contractual duties to a third party. Sounds like they have the same name. They're two different scenarios. Okay, I'm not sure if any of what I just said makes sense, but the idea is this big category of pre-existing legal duty. I'm going to break them down into the types of pre-existing duties and give them different names, so you can think through the specifics of each one rather than this just big amorphous category. I don't think that made particular sense, but maybe it will after I continue to talk about things. So the first scenario we're looking at is third-party consideration. And when we're talking about third-party consideration, we're talking about situations where there is one contract, okay? And what happens is two people are in a contract, but one party is promising to do someone for the benefit of someone who is not in the contract. So imagine a scenario where Layla enters into a contract with a ski instructor to provide lessons to Sam. Layla says, I promise to pay you. And the ski instructor says, by virtue of it, like in exchange for your payment, I agree to give lessons to Sam. In this contract, the benefit that Layla receives is something for Sam. So the one party is providing consideration, the benefit of which runs to a third party that's not a party to the contract. One might think that provides a consideration problem, but it doesn't. The courts say this is good consideration because the thing that Layla wants is to give something to Sam, right? So she's getting something she wants. It just, the benefit she's getting isn't the act itself, right? It's the giving of something to someone else. So the courts say third-party consideration is good consideration. So if you see a third-party consideration issue, again, when you're identifying the consideration, you've defined consideration, you say, in this situation, we have a contract with third-party consideration because the benefit of this party's act runs to whoever the third party is, and that is good consideration. Are we understanding this scenario? Two people are in a contract and one party's promise to the other is to benefit a third party. Okay. So let's think back to our example, the first argument that was made in Boutillier, where the university was like, if you donate money, I'll donate money. Assuming that was a valid contract between the the donors, this is a third-party consideration issue. How so? Andrew?
Just taking a stab at it, but I think the contract would be between the donors, so each party, and then the university would take the benefit of the contract.
Yeah. So it would be like each donor is saying, I'll donate to the university if you donate to the university. Each party is asking for a benefit that will confer on the third party, which is the university, right? The third party the university is the third party beneficiary of an agreement between donors, right? This is fine because each party is getting something they want to get something from the other. This is good consideration. Is this making sense to people? Yes, maybe, sort of. Okay. This is different than a situation of pre-existing contractual duty to a third party. Note, this will also constitute good consideration, but for a different reason. A pre-existing contractual duty situation arises when there's two contracts and one party is in a contract with two different people. Okay, we'll start it this way. I gave you the facts from Shadwell and Shadwell, where a guy agreed to marry, or Ellen and somebody who doesn't have a name that we'll call nephew, agreed to marry each other. And that isn't, at that time, that was engagements were enforceable contracts. So if Ellen decided not to marry the nephew, he could sue her. If he decided not to marry her, she could have sued him. Okay, So the nephew and the fiance entered into a contract to get married. Contract 1. Then the uncle and the nephew enter into a contract for the benefit of the fiance. The uncle says, if you marry Ellen, I will give you X amount of money. The issue that arises, or the reason one might think there's a consideration problem here, is that the nephew is promising the uncle something he's already obliged to do under his contract with the fiance. So has the uncle actually purchased this act from the nephew when the nephew is not providing the act so as to get money because he's already obliged to do it under the first contract? Is making sense? Maybe? Okay. So there's one contract and then there's a second contract, and one of the parties is a party in both. And the nephew is making the same promise to the uncle that he made to the fiance. So this contract is, I promise to marry you, I promise to marry you. This contract is, I promise to give you money if you marry the fiance, right? So the benefit that the uncle is asking for is the marriage to the fiance, right? And the benefit the nephew is asking for is money from the uncle. One might think that would cause a problem because, again, the nephew is already obliged to marry her. So it seems like he's not giving that promise to the uncle to purchase, or the uncle isn't sort of purchasing that act or that promise from the nephew because he's already obliged to do it. But the courts say this constitutes good consideration. Isabella?
So what if the contract happened in the reverse order? So for instance, first the uncle says to the nephew, okay, I'll give you money if you marry the girl. And then the nephew goes and proposes. So would that make a difference in this situation?
It wouldn't. It just would be who is the third party would change. Because in each instance, the nephew is making a promise to one party that he's already promised to someone else. So say it was like the uncle and he were like, if you marry her, I'll give you money. Cool. Then he goes and he says, I will marry you. The question would be, is the fiance now getting good consideration because he was already contractually obliged to marry her? So it doesn't change. It's just who is the third party beneficiary under the second contract changes.
Okay. Yeah, that makes sense. Thank you.
Okay. So in Powon, the court takes on this question. So again, a general pre-existing contractual duty arises when person A is in a contract with B and promises to do something. And then person A enters into a contract with C and promises the same thing as they promised to B. Okay. So in the Powon context, the question is, the Powon family have promised to Fuchip in the main contract that they'll retain the shares for a year. And they've also promised that to the Lau brothers in the second subsidiary contract. Okay. So when the Powon family promised to the Lau Yulong family that they'd retain the shares, they had already made that promise to Fuchip. The court says, actually, that's fine. And they say the reason pre-existing contractual obligations to a third party, and so just to clarify the name, the idea is that the Powon family are in a pre-existing contract. And so in this second contract with the Lau brothers, they are undertaking something they are already have under a pre-existing obligation to do for the benefit of this third party. Okay. I feel like people are like, maybe. I'm just going to nod my head slowly, but I'm not really sure. Questions here? Honestly, ask a question if you're not sure. Okay. People are either just like sure or they're too tired to think about whether they're sure. If the two contracts were made with the same party, would this be a past consideration issue? Well, it depends. Like, I mean, usually you're not making two contracts about the same thing, right? That's why the POW on facts are not great ones to analogize to, because why would they make two contracts about this? Andrew?
So what would be consideration for the second subsidiary agreement from POW on? Would it be like promising to undertake the initial contract?
Yes. And why does the court in POW on say that's good consideration? They say that the Lau brothers gain the benefit of a direct obligation. What is that? So ordinarily, if there was no second subsidiary contract here, there would be a contract between Fuship and POW on and the POW family. The Lau brothers would not be involved. They'd be like, they're not parties to this contract, right? So the only parties who could enforce it are Fuship and POW on. Now that the POW family have made the same promise to the Lau brothers as made to Fuship, the company, just a bit of an artificial distinction in this case because it's a company and individuals who own the company. But now the Lau brothers could also personally sue the POWs if they don't retain the shares for a year. Because now a breach of this contract is a breach of this contract. So what the Laos, the third party here, gain is the direct ability to sue to enforce the first contract. So in this situation, the nephew and the fiance get married or promise to marry each other. If the uncle appears to really, really care that the nephew marry Ellen, I don't know why, Helen may be an excellent human, not sure. And so if the nephew didn't marry her, the only person who could enforce it is the fiance, right? Because the uncle's not part of that contract. But now that the nephew has promised to the uncle the same thing he promised to the fiance, if the nephew breaches the contract, he's breached both contracts. Either one of these guys can sue to enforce it or both. So what the uncle gains is the ability to enforce this obligation because it's now an obligation in a contract to him. Okay, so what happens is the two parties are in a contract, right? One party enters into a second contract and promises to do the same thing to the benefit of the third party. What this person receives is the ability to enforce this person's obligation to the fiance. Because now it's an obligation the nephew holds to both of them. Prajna?
If the fiance is the one that decides not to marry the nephew, then the uncle would not be involved in that contract at all.
That's right.
Okay, thank you.
Yeah. So if Ellen's like, no, I'm done with your whole family, that's fine. Ellen's the only one who breaches. She's made no promise to the uncle. Okay. Harry?
Hi, so I had a quick question. You mentioned that in the POW on case, the Laos would be able to sue POW on if they didn't fulfill the original agreement to retain the shares. And that's only because they entered into a contract with them. But there's still a third party in the overall situation. So I was just curious. I know in one.
Still the third party in the overall situation.
Sorry?
What do you mean they're a third party in this overall situation?
Like the original contract would be between Fuship and then POW on, and then.
Yeah, the others they're not even. They're just not a party to it individually.
Oh, okay. Because my question was, I know in the readings you mentioned that normally a third party, like somebody that's not involved in the contract, wouldn't have the privity of contract. They wouldn't be able to sue, basically.
That's right.
But in the situation of, in the previous situation where you mentioned the ski instructor, so let's say Sam, for example, is suing the ski instructor for a failure to fulfill the contract? Like the benefit?
Can Sam do that?
Yeah, that's what I'm curious about. I know in
No.
the example, there's a circumstance where she sued. There was a situation where they sued based on what they received from a. Let me see if I can get my notes. Just a second.
So in a third party consideration situation, Sam can't enforce this contract. So if the ski instructor doesn't provide Sam with lessons, only Layla can sue to enforce that obligation. Okay.
Right. I was just wondering if there were circumstances that changed that, because I was reading about a case previously where.
Well, the pre-existing contractual duty to a third party changes that, right?
Okay. Okay.
Because now, so if there was no contract here between the fiance and the nephew, then this would be Layla and the ski instructor, or this would be Layla and the ski instructor, and they would be doing something for the benefit of the fiance, right? But because there's two contracts here, that's why there's a pre-existing contractual duty to a third party, the third party being the beneficiary of the first contract. In the second contract, what the person receives is the ability to enforce the obligation of the nephew to the fiance, because now the nephew has a contractual obligation not just to the fiance, but has a direct obligation to the uncle. Okay, and so the uncle now is in a contract in which the nephew is obliged to provide something for the fiance. So if the nephew breaches, he's breaching both contracts. Either one of these people can sue to enforce. So what they gain here is the direct obligation, the right to sue to enforce that obligation, which they otherwise would not have because they wouldn't have been privy to the contract in which that obligation was initially undertaken. Okay. So Donahue and Stevenson is a tort case, Harry. And so the duty of care is a tort obligation. So it's not a privity issue, and it's not a contract issue. You will spend so much time with Donahue and Stevenson next year in tort law. You'll be like so down there with Donahue and Stevenson, but it's not a contract case. There are ways, which we'll talk about in the privity context, in which there are some other rules that go along with privity, but the consideration point here is that when you have a pre-existing contractual duty to a third party, that's good consideration, because the new thing that the nephew provides the uncle is the ability to sue to enforce this obligation. Okay, so in both these cases, contractual or third party consideration and a pre-existing contractual duty to a third party, in both those cases are good consideration. But on an exam, because as I was saying, you have to identify what is the consideration, you have to explain to me that this is one of those scenarios and this is why it's good consideration. Okay. Howard and then Isabella.
Yeah, so going back to the ski instructor example, if Sam signs a contract with the ski instructor, would that then change it to a pre-existing contractual duty to a third party?
So if there's Sam. Sam, where'd Sam go? There. So the benefit. So the benefit here is to Sam. So if trying to think of whether it ends up being the same. Yes. So if so it's not quite the same, because if these two enter into, so basically it would be like this: if the ski instructor and Sam were in an existing contract, and then Layla entered into a contract, the pre-existing contractual duty would arise from this contract, and she would now be able to sue to enforce the obligation that the ski instructor has to Sam, as would Sam.
Okay, so it has to be one contract first, and then you go on to sign the contract with the same conditions, then that will then arise the problem of, okay.
That's right. And so you're just trying to figure out like to figure out, you know, which contract is which, there has to be an initial contract between the parties and then a second contract where the benefit runs to the third party. Okay.
All right, thank you.
No problem. Isabella okay, Isabella?
Yeah, so my question is actually kind of similar to Howard's. Can't the ski instructor basically charge both Layla and Sam for providing the same service? Essentially, he's getting paid twice for one thing. How does that?
No.
No.
No. So I'll show you why. So in this situation, so it depends on the contract, but so say Sam and the ski instructor, he might get paid twice, but that's okay because that's what Layla is choosing. I'll pay you more if you ensure that you do this for Sam, right?
So what if Sam and Layla are not aware that they both have the same contract with the ski instructor?
I mean, that's still fine. They've still agreed to do she's agreed to do something for the benefit of Sam, and Sam's agreed to do it for the benefit of himself. There may be other issues that can arise, not around contract creation, but like whether there was a misrepresentation, etc. Whether lies were undertaken, but it's not a consideration issue.
Okay, so in reality, the ski instructor, he'll get in trouble for charging them twice for the same service. Am I understanding that right?
If they're not aware, then we might be able to say that when we get next semester to the concept of a misrepresentation, like that he's sort of tricked them. If that's the situation, there are other doctrines that deal with that, but it's not a consideration problem.
Okay, perfect. I can sleep easy knowing that.
But sometimes Layla will say, like the uncle was like, I'm going to pay you. I'm going to give you an extra thing, right? Because I really want that thing for the third party. Okay. Other questions here? Okay. We're going to stop now, and we will take up variations next week. I'm going to try and hold, I'm trying to figure out if I can do another tutorial between now and the end of the semester. Usually I try and do one on the last day of class, but I think it might actually be more useful to do one a bit earlier. So it might sort of help a little bit more with studying. So I'm going to try and figure that out. Yeah, we'll either do a tutorial next week or we'll start variations. I'm not sure, but variations will be our last topic here. And I will figure out this answer to this question by tomorrow or Thursday. I will talk to Professor Aroka. She might have time to chat with you guys before the last day of class, even if it's not in this class. I'm not sure, but again, the high flex thing is just the high flex thing. I don't think it changes that much based on the individual prof's methodology. It's more just that whenever there's high flex, there is the difficulty of trying to manage the two different constituencies. But given like everybody wants a different thing, there's not that many ways around it. It's hard to have just in person because people may need accommodation on a variety of different fronts. But don't blame me for any of those decisions. I'm not involved. I'm passing the buck. Thank you to the administration. Okay. Do come see me during office hours. I just sit there by myself, sadly. I know you guys are busy and you've got a ton of things, and it would be more useful if we could just do it now. But you guys have lots of other things. So take advantage while you can. And I will see you guys next week, and I send you much energy And I mean, it's stressful time. I can't take away the stress, but I can't do anything, but accept help when you want to come see me. And I will see you guys next week. And you have a tutorial tomorrow. Bye, guys. I'm gonna go, Sarah.
Okay, we'll talk soon.
Unless you
Bye.
want to chat. Do you want to chat?
No, I'm all good.
You're good.
Unless
Okay.
you want to chat.
I don't want to chat.
Okay,
I'll talk to
bye.
you soon. Bye.
Bye.